Paul, would you like me to do an intro or would you like to begin?
Oh, I can just do it.
Um,
So Purdue Global is a California accredited distance learning law school. Its recent attrition rates between the first and fourth year classes have been over 70%. Purdue already gives its own proprietary pre-admission test to candidates in lieu of relying on the LSAT or other tests, and admits those who score 20 out of 40 points or above. To address the attrition rates, it proposes to offer a not-for-credit pre-admission 8-week program to those who score between 20 and 23 points to help increase their chances of succeeding in law school. If the committee gives its approval, the program may begin as early as January. Staff recommends approval of the request and has prepared a motion to that effect. The motion includes requirements that certain changes to the program, such as giving credit, must first be approved by the committee and requires periodic progress reports. You want to put up the motion, Natalie?
sure. Viviana, can you help me with that? Thank you.
So first we will hear from Dean Pritikin, who under our normal procedures has 5 minutes to speak on behalf of the school. Then we'll take a motion and then questions and discussion from the committee.
Thank you. So he's raised his hand. He's ready to be recognized.
Hi, can you hear me okay?
Yes.
So thank you very much for the opportunity to present. I realize that you are under a tight time frame and I don't want to take up that time. So if it's with the chair's permission, I'm happy to just answer questions anyone may have about the proposal and not actually make a presentation, if that's the preference of the committee.
Works for me. Somebody want to make the motion that is on the screen?
This is Jim Efting. I'll make the motion.
I'll second it.
Okay, Efting and Gongora. Any questions, discussion, questions for the dean? Vince?
Vince, sorry. Vince, you're muted.
That's twice.
Yeah, I'm trying to set a new record. Can you hear me now?
Yes.
Yes.
Okay, thank you. I really like this particular program. I mean, we talk a lot about diversity and inclusion and equity and those kinds of things. And it seems to me after reading about it that this program is trying to address those problems in a way that I think is very positive and fast, and in a way that some other schools may benefit from this type of model. So I'm very encouraged. But I do have some questions. If it's appropriate to let us know, how is this being funded? You have a great team, it seems, that want to do the implementation. So my first question is, how is it funded? How are you actually able to do this? And then secondly, how will you track people that go through? And then my third and last question is, how do you do outreach on this? Is it students that are already enrolled or want to enroll? So those are my questions.
Sure, I'm happy to respond. So first of all, we are funding this ourselves. We think it's an important retention initiative, which is worth the investment. It's actually not a significant investment financially for us because we're going to have full-time faculty teaching these pre-admission programs. So they're going to get some course relief from their other teaching loads. So we'll have to, possibly have adjuncts cover some of those. But we actually just hired 2 more full-time faculty as of Monday. So one of them is going to be teaching this. And in terms of the development, it's also not really costing us much because As the proposal noted, our assistant dean of students, who wrote her PhD basically on this exact topic, is taking the lead on designing the course in collaboration with other faculty. The hope and expectation is that the improved retention that will yield from this program will essentially pay for itself, right? That will have more students staying in the program longer, and that will more than offset whatever costs we incur from offering it. In terms of the second question about how we're going to track these students, so we track both student performance and student persistence. And so we have historical data on how students with these entering predictors do. And so what we're going to do is we're going to compare how students who make it through this program do compared to that baseline. And for us, first year retention is really the key thing, because for most students, if they make it through that first year, they're going to make it through the rest of the program. As any online program serving part-time students, adult populations, we're going to have higher levels of voluntary attrition than traditional schools, right? People who just decide they're too busy to juggle law school on top of their job or their families, whatever. But, hopefully this will reduce some of that, but more significantly, the involuntary attrition. And then the third question is the outreach. So basically, we're not going to be requiring this of existing students. So assuming this gets approved, the plan will be that starting in January of 24, when we're enrolling students for the next term, which is in May 24, those students who score between a 20 and 23 on our admissions exam, rather than just offering them admissions outright, those students are going to be told, okay, well, we're not going to be admitting you, but we do have an opportunity for you, if you're willing to undertake it, that will allow you to enroll the following term in August. So that's the plan.
Dean, I'm really encouraged by this. I mean, it's very difficult to put together a DEI plan, but I think something concrete like this is really, really very encouraging. So the best of luck if we approve this.
Well, thank you. Well, obviously, we're hoping that this pilot works, and we're going to track the data to try and prove that it works. And if it does, we do hope that we can share our findings with other schools and hopefully be a template they can follow.
Jim? Muted.
I'm unmuted. So, where are you getting the expertise to teach this class? Who the people who are going to basically providing the material to help the students? Are these going to be former attorneys or current attorneys? Are they going to be teachers? Where's the information going to come from to teach the class?
So the primary designer of the course is our assistant dean of students. She, in addition to her JD, has taught bar prep and academic support at 2 ABA law schools before coming to us. She also, about a year or two ago, completed her doctorate in education, and her PhD was, her dissertation was focused on retention of minority students in an online graduate setting. So pretty much, threaded the needle as close as one could imagine to this type of program. The professor who's going to be probably teaching the sections has taught both academic support skills and doctrinal classes for us. She also has an extensive experience as a practitioner, primarily in immigration law, although she's done some other stuff. And she herself is a non-traditional student. She actually went to law school in her 30s after having had a career in computers. So we believe that their expertise, and they're actually consulting the research literature about what works. And there are other problems. The ABA, in conjunction with, I think it was Access Lex, has recently done a pilot program somewhat similar, although longer. So we believe their expertise combined with consulting the relevant literature will give this, as good of a chance of success as we could reasonably hope.
Thank you.
Thank you.
Alex?
Hi, Marty. I got a question for you. So looking at this program, for those candidates who score between 20 to 23, and I think the plan, as you laid out, is to get them through this 8-week flex program on a non-credit basis. And then, assuming they are able to pass those courses and obtain a GPA of 2.0 or higher, then based on your recommendation, the candidate will be considered for admission to the JD program. Two questions about that. One is, if they do get a grade of 2.0 or higher, what other criteria would be considered for their admission into the JD program, or is that enough for the school to consider them admitted into the program? Question number one. Second question is, looking at the other part of the report, I appreciate law school, trying to raise the bar by increasing the GPA level for students to remain in good standing from 2.0 to 2.5. And so the question I have, the second question would be, why didn't you designate 2.0 as the requirement for those who score between 20 and 23, and instead you have only designated that 2.0 would be, enough for them to be admitted to the program?
Yeah. So thank you for this question. So first of all, basically, these are going to be applicants who will have already been evaluated for admission prior to entering the Flex program. So, in addition to looking at their admissions exam score, we look at their undergraduate GPA, we look at if they have graduate studies, prior work experience, we look at their personal statements, and of course, we make sure if they've had prior law school, we look at that. We look at whether they've had any academic discipline or disqualification and any criminal history. So that will all already have been reviewed by the time they enter the Flex program. So assuming they successfully complete the program and assuming no issues arise during the program itself, if they cheat during the Flex program, that's going to be a problem. But we don't really expect much of that. So barring that, they will already have been evaluated and they would be admitted. The second thing I should point out is that it's actually not a 2.0 that we're going to require. It's really going to be the equivalent of a 2.2. And the reason is that, we were trying to balance, on the one hand, we want to require them to demonstrate that they can perform at a level that suggests it's likely they're going to be able to succeed in law school itself. On the other hand, we didn't want to require the exact same standard as we expect of our students in law school because they haven't actually had law school yet. And so, our data shows that the students who start law school and they get a 2.2 have a decent shot of making it off probation, right? If they're below a 2.5, they get on probation. But below 2.2, it gets much harder to do that. So a 2.2 is a standard that we're going to require. And again, this is sort of our best assessment of what we think is going to be fair and useful for them. Once we run the program, if it turns out that, only the students who performed in the pre-admit program at a 2.3 or a 2.4, they're the ones who tend to make it and the 2.2s don't, we might go back to the committee and say, hey, we want permission to, revise those standards. But that's why we're doing it in the first instance for the pilot. I hope that answered the questions adequately.
Yeah, I guess my concern is still that it sounds like we're lowering the bar, especially for those candidates who couldn't score higher than 23, and somehow, you're trying to set a lower bar for them. I understand you don't want to equate them to the law students, but again, I think, if you were to require law students to maintain 2.5, I think what makes sense for those who are trying to get in the program to have similar, if not equivalent GPA, instead of trying to lower the standard for those who actually couldn't get anything higher than 23 and give them a lower a score to get admitted to the program. I think that's really just my concern. Obviously the school, we've deferred to the school as far as what it feels best, but I certainly would advise you to consider, if the program later on indicates through analytics or otherwise that, it may probably serve better for the candidates to raise the GPA, that you do so and consider that.
No, we're absolutely open to that. And again, just to make clear, so it's not lowering the bar from current standards in the sense that right now, those students with 20s to 23s, we're admitting, but we're not giving them this extra support, right? So it's not like we're saying right now you need to score a 24, but now with this program, we're going to consider 20s to 23s. we've already been considering the 20s to 23s, but now we say, hey, we're not comfortable letting you in without giving this additional support. Rather than just raise our standard to a 24 and not let you in at all, we're going to give you a chance to prove yourself, right? Because your entrance exam score suggests you're at risk of not succeeding. Demonstrate to us that you're willing to put in the time and that you're able to perform a level that shows you're on your way to performing in law school, and we will give you a chance. So this is, technically it's stricter than what our standards are now. It's not lowering the bar, it is raising it for these students, just not all the way to a 2.5, if that makes sense.
Understood, and thank you for your input, Dean Martin.
Thank you.
So, Alex, for context, it might be helpful to know that historically, with the Concord, now Purdue test, they required a 24 for admissions, and then around 2018, 2019, they changed the format of the test to remove some true false, replace them with multiple choice. At that time, they dropped the number to the minimum of 20, in some cases, generally 21, and so those students have now, gone through a full cycle, and the school is reevaluating. It's hoped that part of the diversity requirement that you created for accredited schools under 4.160C will promote this sort of innovation combined with reevaluation and taking action. And so this could be an early example of that.
Agreed, and I think Vince already indicated this seems to be very innovative, and we look forward to seeing success in this program.
And then Dean Pritikin, just a quick clarification. So it sounds like coming out of the gate with a pilot, the school will require a 2.2 cumulative GPA for the 8-week program. Is that right? That'll be the minimum?
Yeah, it's we require basically a 65, which on our grading scale corresponds to approximately a 2.2.
Thank you.
Any other questions? Okay, we have a motion and a second, so I guess it's time for a roll call.
Dr. Bolton,
Yes.
Robert Brody, Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes,
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 14 yeses and 0 nos, the motion passes.
Thank you all very much. Appreciate it.
Thank you very much, Dean, for your time. So, Audrey, can I ask you, so how long do you anticipate the special set will be? So we know when to inform the public that we'll be going back to open session?
I'm not sure if Lisa has a different thought, but probably 20 minutes. What do you think?
Yeah, if there's not a lot of discussion, I think it's a pretty straightforward item. So 20 minutes, 20 to 30 minutes at the most.
Or should we just say 30 minutes then, Lisa?
Yeah.
Uh, Okay, so it's 12:57, so 30 minutes from now will be 1:27 p.m. when we'll go back to open session. So I guess, Audrey, we all go to closed session now, is that correct?
Yes, I sent everyone a calendar invite to close session earlier this morning, so you should have that. And then we'll come back right back to open after that item.
Okay, sounds great. We'll see everyone in closed session.
Do we leave this session?
Yes.
We actually hit the leave button? Okay, thanks.
Does it look like we have most people back?
We do have a quorum. We're still waiting for some more members to join back into the meeting.
Give it a few more seconds here. I know everyone's logging back in, I'm sure. All right, so we are back in open session. We will be talking about the agenda item number 4 in open session, which is under operations and management, which is action on revisions to the admission rules pertaining to Chapter 6, conduct violations, recommendations to circulate for public comment. So I will turn it over to Ashley, Jim, Tammy, and Bethany for that. I'm not sure who's going to be speaking.
Thank you, Dr. Cal. I will be the one taking the lead on this. We previously brought this agenda to the CBE back in April of this year, and we decided to pull it, and we worked on refund of fees policy separate, and then we came back around, and now we're bringing you the Chapter 6 rule revisions to look at those independently for the changes that we have made. You will see from what you reviewed in the attachments for the agenda that the rules have substantially changed from what they previously looked like. Some of those main changes that are in the rules are that we did add additional examples of some more electronic devices for applicants to be able to see. We tried to clarify what an indisputable versus disputable sanction or violation would be. We also are proposing to discontinue Attachment E, which was a religious headwear policy created by the CBE back in March of 2014. That required applicants who needed to wear religious headwear in the exam room to petition prior to the exam. And if they did not, once they were on site, they could petition then, but they would be issued a Chapter 6 notice of violation. So we are asking to rescind that policy, and they will no longer be required to do a petition, submit a petition, or have any issues with Chapter 6 notices. Another aspect that we're asking for the committee to approve is allowing applicants to bring their own bottles of water in the room now, within guidelines that we will present to the applicants with regards to the size. Needs to be a clear bottle, no labels and writing and things along that line. We also made a point to try to clean up the Chapter 6 matrix. That is all of the conduct violations, and it identifies what those sanctions would be if somebody was to receive a Chapter 6 notice for that violation. That included that we remove the religious headwear. It includes that we update it to allow the water in the room as not being considered part of the unauthorized items of food and beverage. And we also added a new item to that, which is a new violation of altering answer files after the exam has finished. As we have seen in the past several administrations, we have been able to see that we have reports that provide us with information with regards to if an applicant is in an exam beyond the amount of time that is allocated for that session. So we are now adding that as a new addition to the matrix. And with that, we are looking at it being a sanction of a 0 for the session that it happens, and that it would be indisputable, not entitled to administrative hearing. We also, with the Chapter 6 matrix, we previously had in there for each of the violations, we would also include on some of the lines whether or not it was a referral to moral character as a matter of course. And the additional change is to remove that from the individual violations and to add a statement at the bottom of the matrix that just says that conduct violations may be referred to moral character, so that we have that flexibility to still include that in the matrix. One of the other main changes to the rules is to eliminate staff being the people who are going to administer the hearings that we do for Chapter 6. Staff already make the initial determination at the time that we issue and affirm the sanction for the Chapter 6 notice. So we would, in essence, be removing a second determination being made by our staff on the hearing itself. We would also be reducing the timeline for the Chapter 6 process to be conducted. Previously, for example, applicants, once they requested the administrative hearing, we had 90 days to be able to conduct that hearing with them. Doing this change with the staff not doing the hearings, this is helping us to reduce the timeline because now we're not doing that 90-day time period to wait for staff to do it. We're going to go directly to the committee with that hearing. And that's the additional change, is that we are proposing we allow the administrative hearings to go back to CBE, which is how it used to be previously before Appendix I, that the subcommittee for operations and management would hear the hearings. So now we're proposing that we have the hearings being heard by CBE as a whole, and that the applicants would be invited to participate in that hearing still, but in a closed session, of course, with the committee. So basically, with that being said, as Paul mentioned earlier, we had spoke yesterday and he had requested some additional changes to the actual language. Prior to sharing those changes, I am going to go ahead and share the motion that was presently in the agenda item, which is for the staff recommendations to be accepted with what you saw in the rules, as well as the agenda item details. It also further moves that the committee rescind the religious headwear petition policy. And it also is to accept the revisions that we had made to the Chapter 6 matrix prior to having a conversation with Paul and his changes being included. So I believe under Rosenberg, we have to get a motion on this, I believe, first, and then I can move forward with opening it up to discussion on showing the revisions that Paul has requested.
I'll go ahead and make that motion. This is Justice Maciwala.
Thank you.
I'll second.
Okay, great. So I'm going to go ahead and take the motion down for the time being. And Amy's going to go ahead and share a screen. I wanted to include that staff have reviewed everything and staff recommends approving the original version that was provided with the agenda that was uploaded with all of the attachments. They feel that the version that we provided does allow due process for the applicants, and that for public protection reasons, we do want to make sure we have flexibility on referrals to moral character, because we do have a duty to report anything that implicates an applicant's moral character. So with that being said, Amy is going to share a document and we can go over the changes that Paul has requested and open it up for discussion, and then we can come back and look at the motion again at the end.
All right, so Tammy, would you like me to open the matrix or the rules first?
Why don't we go ahead and do the rules first, and I'm open to either item that you want to do, whether it's the red line or the clean.
I'll open the red line first.
Okay, so for the red line version that Amy is opening, I have highlighted everything in yellow that was an additional change after conversation with Paul yesterday, and hopefully I caught everything and didn't miss anything, Paul, but if I did, you can please bring it to my attention. So as you can see in this red line, everything that was originally uploaded with the agenda has already been struck or underlined to show those changes. We have some minor changes with recommendation from Paul was to strike the words by as, to make it be clear to say that we are including seeking to receive assistance. Item number E is a new addition that Paul has requested, which is to include that no Chapter 6 notices shall be issued after the release of results of the exam. Violations discovered after the release of results may be referred to the State Bar's Moral Character Unit and or the Office of Chief Trial Counsel if they are an attorney. The Chapter 6 notices, I have not in my time seen any that have been issued after release of results. Usually we are aware of any violation prior to that. So I just wanted to provide that as some background for you, that this is something that I've never seen as an issue that we've ever had come up, but this is an addition that Paul had requested. Amy, if you want to, I don't know if everybody wants to talk as we go, or do you want me to just go through it all and then open it up?
Or maybe Paul could talk about the intent.
Yeah, that's true too.
Yeah, well, you need to go down to the other changes about the timing of the decision.
Amy, go down to, I think it's 4.72. Is that right there? I think is where it is.
Right here in B.
Yes.
Yeah, so there were some timing issues here where in certain circumstances for a notice that was issued after the exam, because of the way that it was written, staff may not have enough time to issue the notice and allow the applicant time to respond and then make a final decision. And I thought that was that would in effect eliminate the ability of an applicant to respond to a charge, which I didn't think was appropriate or fair to them. So we just reorganized it to say that staff's obligation to make a decision occurs 35 days after either when the last day of the exam, that would be for notices that were issued during the exam, or 35 days after the notice is issued if it's issued sometime after the exam. And then Tammy told me that we never issue notices after the results have been issued, so I thought we should write that down. I am not of the mind that because it's not likely to happen that we shouldn't be clear about it, which seems to be underpinning staff's implication that there's no need to make that earlier addition to the rules. I don't know if that was clear, but so go back.
Actually, do you mind if I ask just a clarifying question? Because I mean, as the committee is aware, sometimes OGC assists admissions with drafting the rules to try to get the maximum clarity for applicants, just because rulemaking can be kind of tricky sometimes. And so we actually helped in trying to make this as clear as possible, like the timeline. Sorry, Amy, can you scroll down? So yeah. The reason for it being drafted as it is that this rule, the original drafting basically says that as soon as the state bar becomes aware of a potential conduct violation, they have to issue the notice as soon as possible. And then within 35 days of becoming aware, they have to affirm or deny the notice. And so that gives staff flexibility where if they become aware, like let's say, it's never happened, but let's say we get clear and convincing evidence that an applicant cheated on the bar exam after the results were released. Like somebody shows us a video of them cheating on the bar exam and that's how they got their passing result. Staff would need to, for public protection reasons, have the ability to issue a Chapter 6 violation in that case, regardless of the timing. And this would give them basically 35 days from the point of being aware that happened to do something about it. So it does give applicants some certainty as to the timeline while preserving public protection, because it doesn't cut staff off from their ability to serve a Chapter 6 notice where appropriate.
Oh, this isn't. No, I don't think this is cutting it off. First, let me say Tammy, when we talked yesterday, you were talking about having a underlined strikeout showing just my changes to the clean copy. And that's not how this is presented. So it makes it harder to see what I was trying to do. My concern, Caroline, is that the notice doesn't have to, this doesn't say that the notice has to be issued immediately upon becoming aware of the conduct.
But effectively, it does have to, because they only have 35 days to affirm or deny. Do you know what I'm saying? So it doesn't really matter when they issue the notice. What matters is if they affirm or deny it, and when that happens, because that's what triggers all the other.
But see, affirmation or denial or disaffirmation only
disaffirm,
comes
sorry.
after the notice has been issued and the applicant has 10 days to respond. So to give them the full 35 days that they would have if the notice is issued during the test itself for these after discovered things, I think you need to trigger the 35 days running from the time they issue the notice.
But the idea, well, so we thought we were being more applicant friendly by phrasing it this way, because the idea is then that staff, once we become aware, the timeline starts and we have to gather the evidence, get the notice issued, and get it affirmed or denied within 35 days. So that's a lot more applicant like friendly insofar as it sets the time and the certainty for them. If we do it from the date of the notice, then staff could theoretically become aware of a conduct violation, take, I don't know how long it would take to gather the evidence, but let's say it takes 30 days. Then they issue the notice after 30 days. Then they have 35 days after that to affirm or disaffirm. So it actually does kick things out further. And a lot of this design was to really cut this timeline down, because we're aware that people want to know whether they pass the exam or not and get on with their, legal career. So anyway, normally I don't talk this much, but because we were helping with trying to get the drafting right here, I just wanted to make sure you understood like our thought process and intent behind that.
Okay, and my way of addressing the certainty was to add that earlier provision that says no notices will be issued after the results are released.
Yeah, and that one's just kind of for me sticks in. It doesn't work for me, because I feel like anytime we become aware of cheating, we really do have a duty to the public to investigate that and to pursue that. I mean, we can't look the other way when we receive evidence. It doesn't matter when.
You're not, because you're referring it to moral character and or trial counsel.
We would be removing one of the public protection, like regulatory tools that we have to combat cheating without a legal requirement to do that. So that's why I wouldn't, personally, I think public protection dictates in favor of having as many tools at your disposal to.
Okay. Well, I wish you could have participated in that conversation.
Well, I know this stuff happens on a tight timeline, and I think your comments it's difficult to write rules well. I will not say that I am like the perfect person at it whatsoever. I just wanted to kind of explain, and I feel bad because I know Tammy had a lot of input from us on how to try to get this right, and then for her to have to explain it all exclusively didn't feel right to me. So I just wanted to let you know what we were thinking.
And Paul, if you would like the clean version to be shared, Amy does have that. She can take down the red line and show.
No, that's okay.
Okay.
It's just my changes are buried in other changes that were proposed by staff. So let's move forward then.
All right.
Okay, so some of the additional changes in yellow are the wording of conduct resulting in any sanction. Basically just removing the as a matter of course, so that way it's just a very clear sentence that the moral character unit will be a factor in the applicant's moral character process.
Okay, let's stop there.
Okay.
So this one stuck in my craw because the sentence starts out saying that sanctions may be reported. And then it had this tag, which I think came from council, if I recall correctly, as a matter of course. And to me, the phrase "as a matter of course" suggests that it's automatic or nearly automatic. So I saw the may, being discretionary as conflicting with as a matter of course, and that's why I'm recommending its deletion. And it also turned out that the draft of the matrix had inadvertently deleted the language that showed which factors or which sanctions are reportable and which are not. So that's being restored as well, right?
So I have added it to the version that was, yes, a mistake in, I was supposed to strike through and I accidentally just thinking I just deleted it from everyone. So I've added them back in to a red line and a clean version that shows them in there, and it'll have to, see if everybody agrees whether or not they should be there or if we should keep them out. So we can go over that when we get to the review of the matrix.
Okay, so paragraph D is simply a typo. And paragraph E is just adding, so we know, a requirement that we describe the violations which are reportable, and presumably that will be done in the matrix, so that's publicly available.
And so I'll also just say, sorry, Paul, this was one other thing that sort of drafting wise, I think I can speak to. One thing that I think we all really want to make clear is that, again, like, staff has a duty to report anything that could potentially implicate someone's moral character to moral character. So we're never going to promise an applicant, like, for example, that we're not going to report their Chapter 6 violation of moral character, right? There's no situation in which we're not allowed to report something. So I thought it was a bit confusing that certain sanctions had this almost suggesting that it's like a specific sanction related to the conduct violation, when in reality, reports to moral character are made anytime there's evidence of potential factor that implicates moral character. So because it's not like staff, like, for example, it wouldn't be right for staff to be aware of like a factor that might weigh against them in the moral character process to withhold that information for moral character. It would just undercut our regulatory mission. So that was kind of my concern, was more that it looked like we were somehow promising that we wouldn't report certain things.
Well, that's the
moral
impression
character.
that's the impression I got, that we wanted to do that, and I was fine with it. So I can you scroll up a little bit, Amy? So this sentence here in C, it sounds to me like the use of the word may is, maybe we should be clearer and say conduct that implicates an applicant's moral character will be reported to the moral character unit. Is that really what you think we should be saying, Caroline?
Conduct that I mean, to the extent that we think that's clear, that implicates an applicant's moral character.
It shouldn't be
I mean, it's a little vague, but I get what you're saying. That's exactly, I think that's exactly what we should be doing. I do think staff should have discretion. Like, for example, one person inadvertently bringing a cell phone into an exam room versus another person who intentionally brings a cell phone into an exam room to cheat. Those are two different situations, and perhaps the former situation doesn't warrant a referral to moral character, but the latter does. So there is some discretion, I think, in that.
Yeah, I see that that's in the word implicates. The staff has to decide.
As long as, I think that's fine. I think that's fine, because I think what I would love is just for it to be clear to applicants that really potentially any conduct violation could result in a referral to moral character. If it implicates, as you said, to use your terminology, if it implicates their moral character, right?
Yeah. Okay. I like that.
I'm going to use a strike through here, but what I don't know is if this is original language or Paul. So I'm just putting that out there as a caution. So will be reported to the moral characters unit for consideration as a factor. And then does that mean we keep the as a matter of course or not?
I think you keep that struck out.
Yeah, leave it out.
Leave it out. Okay.
Yeah. Okay, it sounds like we're saying the same thing on that, so that's great. And I think you're right. As a matter of course doesn't quite capture the meaning there, but that was what we're thinking of.
Okay.
Okay, move on.
Okay. So we were
Need to go up to A.
So
Back up, Amy.
A here.
Yeah, to A right there. We didn't really touch on that one. Paul, you and I have discussed it. We removed via email based on, yes, they're doing it through the portal, but they can email it to admissions. But what we did is we added the word electronically after you and I had talked yesterday, just so that we can try to emphasize that it's going to be an electronic process, whether they email directly to admissions email or if they go and do it through the portal. We prefer that they're doing it through the portal though.
Okay, I agree.
Okay, great. And now we can move on.
All right. All right. Anything you want to say about E here?
We're trying to make E clear that if they have a pending appeal, we're going to apply the proposed sanction in to the scores that are reported at the time the results are reported, and then if the sanction's later modified by one of the people that can do it here, the scores will be revised. It's just it's much clearer. I think it's much clearer language, but it's not changing the meaning.
Okay.
And that may be it. Let's see.
Yeah, that was all the changes that you had, Paul.
Okay.
Okay, so I'm not happy with I don't think it's the best way to approach it. To the first discussion we had about the timing of staff's deadline to make a final decision on the notice, but since it's only going to bite staff in the butt, if it's left the way it is, I'm willing to put your butts at risk and leave it, not make my changes there. So that would involve no E, no, and no changes to the deadline.
Which was B, right?
B.
Yeah.
So B would stay as it originally was.
Okay.
Yeah. Okay. Carol, my discussion with Caroline raises the question then, we probably should not be designating specific violations as either reportable, as reportable to moral character in the matrix then, because they're all up for grabs, right?
Yeah, that was kind of the thought of putting in the applicants on notice with that more general footer that says like basically any of these could be reported to moral character, and maybe that could even have a cross-reference back to that rule that says a violation that implicate or conduct that implicates an applicant's moral character will be reported to moral character, something like that. So that would give the flexibility, but also the notice to applicants to be aware that any misconduct during the exam could be reported.
And we can move over to sharing the chapter 6 matrix if you want to go that direction to look at those.
Okay.
Yeah, let's make sure that we should highlight it for everyone else. I don't think there were that many changes then.
No.
And so Paul, are you going with the direction now that we're not going to add the specific this moral character to each one then?
No, I don't think we should, because that implies that the others are not subject to that, and that would cause you to perhaps violate your duty.
Okay, so Amy has the version that shows the change with what Paul had requested to add it back in. So in essence, those underlined sentences that say the incident will also be referred to moral character, we would strike those, which was not in the original version that was attached to the agenda. So the original version would, I think, still stand, because I don't think, other than I made one change where I forgot to remove the words "and water," I don't think there were any other changes you had directly on that. Did you, Paul?
Let me just take a quick look, but I don't think so. It'll take me a minute, so see if others have questions.
So does anybody else want to have discussion about all of the above?
Oh, there was one thing related to water. You also had you had water in here. That was correct.
Yeah, that's the one that I mistakenly did not catch to remove when I was doing the revisions. So that is down under, I think it was under the remote exam area.
Yeah, that's all I had.
Yeah, I think
Okay. And it was
here, number line 18.
Yeah, I removed "and water" because we're now saying already prior to that that we are allowing them to bring a clear bottle.
Okay.
So at this,
this item will remain.
that will remain, yes.
Except instead of "conduct resulting in any sanction may be reported," we'll use the same language that's reflected in the rule right now, which is
that implicates.
That implicates, and it will be reported rather than may be reported.
Right.
Okay. All right, we'll make those changes.
And do you want us to reference in that line? I think Caroline or Paul, one of you suggested that in that line down below, we reference what rule that goes back to within the rules themselves.
Yeah, it doesn't hurt.
Okay.
It was
And then,
Caroline's
sorry.
idea, but
Yeah, you don't have to accept it. It's just a thought. Just a point of order that I think the easiest way to go about the motion for this, because there's already a motion on the table, recall, is to have Paul make a friendly amendment to the motion with the changes that he wants to advance, and then see if there's a second, and then have the committee vote on that motion. Does that make sense?
Yeah, Tammy prepared a second motion in preparation for this.
I did.
Okay, but I'm just saying, so the procedure would just be, it's a friendly amendment to the motion on the table, and then you've got or the motion could be withdrawn and you could do a new one, but I'm just, probably the friendly amendment is more accurate, but.
Okay.
So if we do the friendly amendment, I do need to change the word on the motion to say the newly updated changes, right? Or how do you want me to word it?
Yeah, you meant show us it.
Yeah.
Amy, you want to let me share my screen? All right, you're good. Okay. So this is currently how I had done the version 2. Was that I didn't want to use the word revisions twice, so I just tried to say that we circulate the proposed rules with newly updated changes set forth in attachment A and B. The matrix does not go to the Supreme Court, so those are going to be included on the next slide, or the third slide, I should say. That this says adopts the revisions to the Chapter 6 conduct violations matrix with the newly updated changes. So I could change this because we're not going to make any change. Oh, we're going to change the wording. So that would be still applying to that.
And that would take effect. That would be taking effect immediately.
The Chapter 6 matrix would be take effect immediately. Yes, because that's not part of what's going out for public comment.
Okay, and it doesn't require the new rules to be effective.
Well, except that then it can't cross-reference the rule that we just talked about. That's okay.
Yeah.
So we just don't include the rule then.
That's a reason not to include it. Yeah.
Yep.
Yeah.
So basically,
I think the motion, Tammy, the second motion you've got up here is fine so long as all of the members understand what you mean by the newly updated changes, and staff is also clear on what you mean by that, so that when this gets circulated for public comment, it captures all of the intended changes for the motion.
Would we have to maybe, yeah, reference something like a revised attachment? Because it is something that, looking back on it later, I don't know that we would know what it meant.
I think that could be helpful to reference an attachment with the changes delineated.
Like newly updated changes and revised, whatever attachment was the rules.
So I just want to clarify, because my understanding is the matrix is not going to Supreme Court, only attachments A and B for the rule itself is. So are we sending the matrix to the Supreme Court, even though it's not, I mean, it's in the rule, but are we sending it?
Just the rules, just the rules.
Okay, so.
Yeah. But nonetheless, you may want, for purposes of the motion and clarity, to have it refer to an attachment, but still, you're right. It's not going to the.
Okay, so what did you say, Audrey, with that? I'm sorry, because I was on another thought process.
Where are those newly updated changes going to be?
So at this point, I think, Amy, we would need to take the original attachment, which would have been, I think, was attachment C, and we will have to make that change to attachment C for that one change at the bottom. Let me open up.
It's attachment C, I believe, and attachment.
Yeah, it's attachment C, but the version you have, of course, Amy, is the versions that had the changes that Paul made, but now that we're not making any changes other than to remove and water, and the line at the bottom is going to be clarified to match what was changed in the rule without referencing the rule. I do
Tammy,
think
I would just adjust just the motion to just say, with the newly updated changes as reflected in revised attachment C.
All right.
Okay.
Revised,
and then
it's attachment C as well as attachment A.
Well, that will be on the other slide, I think. Yeah.
Okay.
Okay.
So,
I'm sorry, as reflected in revised attachment C. Okay.
all right. And we're good for that. We're still good for this religious headwear. Are we all on board with the motion for A and B attachments the way it's worded, or do you prefer that it be reworded in a different manner?
Well, that will have, sorry, go ahead.
Attachment D is actually the clean version of the matrix. Isn't that the one you would want to revise? As opposed to?
Yes, attachment. If it's D, then yes, it would be attachment D.
Okay, and the clean one of the amendments is attachment B, as in boy.
Okay, so we only have to worry about attachment D, right, Caroline? Because that's the clean version.
And you're going to modify it a little bit more.
Yeah, sure. That's fine. But for the other one, let me just see really quick. Committee recommends that the board proposed rules with newly updated changes. See, you can't do the clean one when you're saying, you can't do the clean one when you send it out for public comment, right? You have to do the red line.
Okay.
That's true, yeah.
Yeah, so I think you'd actually say, yeah, so you'd say, as set forth in revised attachment A.
Those rules.
With newly updated changes set forth in revised attachment A.
You just need that revised.
Those rules with newly revised instead of updated.
No, sorry. Just in just in front of attachment A, just put revised.
Okay, are we saying newly updated changes
set forth in revised attachment A?
Okay.
Okay, sorry, I know it's hard to edit and everything on the fly, so.
Okay, so there's our motion.
Okay, you have the word in after revised, you should delete.
In revised.
Yeah.
Attachment A. Okay.
And then I think everybody saw what of Paul's is being adopted and which ones aren't. But if there's any confusion on that point, once a friendly amendment is made, then staff can put that back up on the screen and clarify.
Okay, I'll make the friendly amendment, which is both this slide and the following one, right? We'll do them together.
Yep, slide 1 and slide 3.
Okay. And is the maker of the motion rather willing to accept the amendment?
I think Justice Messiwala, right?
I was just looking for my unmute. Yes, I am willing to accept that friendly amendment.
Okay, and I seconded the original, so does somebody else need to second it now that it's been amended, or?
I'll second it.
Thank you. Sorry for all this labor, folks.
So I think at this point, Paul, we have a second. Is there any additional discussion that the CBE wants to have, or do we get to move to a vote at this point? And I have
Sounds like
Vote.
sounds like a vote.
Yeah, there we go. I can't see if anybody's got their hands up, so.
Call
And
the
does staff,
question.
just to clarify before they vote, Tammy, you have what you need on your end for the revised? Okay, got it.
Yes.
All right, good. Okay.
Roll call. Dr. Bolton,
Yes.
Robert Brody, Alex Chan,
Yes.
Jim Efting, Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan, Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you, everyone. Thanks, Paul, for your feedback.
Thank you so much. So the next item on the agenda is the report from the director. So I just want to ask Audrey, is it going to be a long report, or should we take a break now?
People
do you
might have
think it'll-
questions. You want to take a 5-minute?
Yeah, is everyone okay with a 5-minute break right now? I see thumbs up. Thank you, Justice. Appreciate
Yes.
it. Okay, so let's, it's 2:30, so let's come back at 2:35. Thank you. Audrey, does it look like we have most people back?
I think so. Again, maybe if the cameras could come back on. I know Kareem had to step out.
Sure, no
He
problem.
should be back in a few minutes.
All right, so we'll go ahead and then start with the report from the director, Audrey.
Yep, let me share my screen. Okay. The first thing I wanted to talk about with everyone is and I'm sorry, this is not my ideal way of making a slide, but I wanted you to see the entire resolution. So the Board of Trustees at their November 16th meeting moved forward with recommending a pilot portfolio bar exam to the Supreme Court. So we've mentioned this a couple times today, but I just wanted you to see the motion that's going with the recommendation to the Supreme Court about this pilot, because it specifically mentions here about the pilot in number 3 that the board directs staff to work with representatives of the CBE and experts to finalize requirements for the pilot portfolio bar exam, study outcomes of the pilot program, and make recommendations regarding continuation, modification, and/or extension of the portfolio bar exam. So in terms of what we've been talking about all day about next year and our priorities, depending on what comes back from the Supreme Court, this is obviously will be a big lift for the committee. Did anyone have any questions about the portfolio bar exam, what happened at the Board of Trustees meeting, anything? I just want to make sure we're all aware. Let's see if there's any hands. No hands?
So Audrey, this is Michael. Yeah. And line item 3, the one that you had highlighted. Yeah. So in what way will the board work with us, the CBE? Could you elaborate on what you think, how that will happen?
I'm not exactly sure, but what I imagine is if this comes back, the recommendation comes back similarly to what the board sent to the Supreme Court, then the board would, there would be some sort of formation of a task force that includes members of the CBE and experts like psychometricians or a couple folks that are already working with other jurisdictions on these kinds of alternative pathways, and to form a group to finalize the requirements. If you read the portfolio bar exam proposal, it has a lot of great detail, but a lot of things where they said, well, this will be worked out during implementation or during a pilot phase. And so that next year would be the time where all those details would get worked out, perhaps by this task force team. So that's kind of what I would imagine would happen procedurally.
And then to follow up on what you said, so if a task force is formed, does the task force report to the CBE or does it report to the board?
I would imagine it would be both. So because it would be CBE members, we would have something at every meeting of the CBE updating this kind of progress. And then I would imagine that the board would want regular updates, or maybe, because the way that the item was written, talking about next year being sort of this development of how to implement it and then it being fully implemented in 25. So this pilot group, their provisional licenses expire December 31st, 2025. So the idea is that next year all the kinks would get worked out about the portfolio bar exam itself with this group that includes CBE members, and then in 2025 it would be the full pilot with the actual cohort. So all of that kind of stuff being worked out with the timing.
And then one last thing, Audrey, you and I had met with Amy and Alex when we were prepping for this meeting. Could you share with the rest of the committee who wasn't present, including myself, at the Board of Trustees meeting, if you could just do a quick summation of that, independent of what the motion was, so that the rest of the CBE heard the same thing that Alex and I heard as well too? That'd be great.
A summary of
just a brief summation.
Yeah, no, that's fine. I'm trying to think of what I might have said earlier this week. So the item itself was a return from public comment, and the public comment about the portfolio bar exam was vast. There was almost 3,000 public comments, I think, 2,814 in the final tally. Largely, a lot of the comments submitted disagreed with the proposal. But it really depended on the sector. So I think it was 87% of those who identify themselves as California attorneys disagreed, but 84% of folks who said they were not attorneys agreed. Lots of organizations wrote in, some agreed or agreed with modified. And then there was a large coalition that all signed on to the same LA County Bar Association letter that disagreed. So kind of breaking down, so part of the presentation was breaking down the comments. And then a lot of the presentation was talking about how the pilot would work, the pilot being these about 100, I think it's exactly 117 remaining original provisional licensees from that 2020 pandemic related group, and then talking through how the pilot would be developed in what you see here in this motion. We also had 3 members of the CBE called in during oral public comment of the board. So Alex, Jan, Paul called in, and then Kareem also called in. So it was a lot of participation from the public and some representation at that meeting from the committee as well.
Thank you, Audrey. I just wanted to make sure that in the fact that we want to be transparent with everything, Alex, Shannon, and I had met with Audrey and Amy, and just want to make sure that the rest of the CB knew what we had heard as well. And I wanted to thank Alex Chan, Paul Kramer, and Kareem Gangora for attending and calling in to the Board of Trustees meeting as voices from the CBE.
Thank you. And just because I see it on screen, one large difference between the staff recommendation and the working group's proposal is to add here under this further resolve that there be an objective assessment component of up to 2 performance tests. So not just the work product review that is recommended in the proposal, but then it also an addition of performance tests into this pilot. So that's just a difference if you've read through the working group's proposal. I think Amy is next with the pilot bar exam.
Yes. Hello, everyone. I think I know I provided a highlight of the pilot California bar exam experiment. We just completed that at the October meeting and was scheduled for October 21st. A total of 2,462 applicants were invited to attend and to participate. Our incentive for that was we incentivized or attempted to incentivize participants by offering them $50 for their participation. Also, the top 3 performers were also offered, or they will be offered $200. So that will happen once grading is over. As well as, the obvious, which is getting feedback on bar exam-like performance. And so on what they would, bar exam-like questions, I should say, because they got essay questions and they also received multiple choice questions. So essentially we got a total of 171 participants on that day. 26 different law schools, California law schools were represented, and we had ABA and non-ABA law schools. For this experiment, we tested 2 variables, so testing timing, and so we looked at timing differences. So people were granted different timings for both the essays and the multiple choice, and we also tested different open book options. So some people were offered open book, some were not. And those that were offered open book, they were offered open book, meaning they got to bring in their study notes. Some were offered the ability to use Westlaw, and some were offered the option to use open web. That is, they could use the open web or open notes. anything except AI or contacting somebody. So they could not chat with anybody or use AI. And so we're in the grading process, so we'll have a better sense. Students should anticipate getting results around between December 15th and December 18th. And so that's where we're at with the experiment. And again, the experiment was really to learn about both the logistics and the process for the actual California bar experiment. And that is scheduled to happen in April or May. We are hoping for that initiative to have to get 2,000 study participants. We're inviting all California law schools. We're considering potentially opening it to out-of-state law schools as well. We've met with, we brought this idea and announced this at the Law School Assembly because we're really trying to figure out how to increase student participation. We're going to bring it back to, we're bringing it to CS bars next week to explore ideas. One idea that came up at the Law School Assembly was one way to incentivize this is maybe offering a free, like a free waiver to waiving the exam fees because they are they're costly for applicants. That's, you know, the grant that we received to conduct this experiment could not cover this for all applicants, but maybe we could offer a few or do a random drawing for some applicants. So we're exploring that option. But we're looking at anything else. So we're gonna bring this again to the CS bars to find ways that we could increase student participation. For the actual experiment, we're looking at 3 different variables. Again, we're gonna use look at test time, looking at the different testing times to see how much that affects performance. We're gonna look at the open book modalities to see how much that affects performance, and also remote versus in person and how much that affects performance. So we will be reporting back to the CBE on each of these and also on the experiment results once we have completely finished the analysis on that. But that is where we're at with the bar exam experiment. Any questions or concerns?
Yeah, where will the questions from the actual bar exam experiment come from? Will they be selected specially for it, or the February questions, or what?
Oh no, we are. There are questions that are coming from our banks.
Do we have enough in the bank that we can afford to burn a few?
Yes and no. I mean, yeah, we should probably talk about this a little at another time, but yes.
I think Amy's worried about skewing some of the results of the pilot by telling you the
source. I think that you know, we really want our students to prepare for this. So yeah, you know, for exam security purposes, we should probably talk about this in closed session, which I could definitely add at a future agenda.
Yeah, maybe we could talk through the experiment details in a closed session item.
Okay. It's still mild curiosity on my part.
Oh yeah, no problem.
Just mild.
Mm-hmm. Any other questions? All right. Well, thank you.
Tara.
Thank you. So we talked about some of these during the planning session, but we just wanted to give you an overview of where we're at with the rules revisions. We know we have several of them pending. And if you recall, the board was only hearing rules revisions at 2 meetings last year or this year. Next year, they're going to hear them at 3 meetings. So it'll be March, July, and November. So I think we've said this a couple times, but just to be sure that everybody is aware, so the testing accommodations rules and the 1 examinations rule, they were approved and transmitted to or will be transmitted to the court for approval. And then in January, we plan to bring back the PTLS, LOS, and moral character rules, incorporating the court's feedback. and then they'll go out for public comment. So we're starting the cycle essentially a second time with those. And so for the March Board of Trustees meeting, so we hope to get those 3 out for approval for public comment. And then you might recall earlier this year, you looked at the multi-jurisdictional practice, foreign legal consultant, and then out-of-state attorney arbitration counsel rules. Just based on the board's workload, they did get pushed from November. So that's when they'll go back in March. And then the rules you just talked about today, chapter 6. And then you'll see for July, we have the eligibility rules again. Those are ones that you looked at already this year, but based on the board's workload, unfortunately, they're not going to get in front of the board until July. So any questions? Okay, thank you.
Tony?
Thank you so much. I'm going to give just a quick abridged version of a presentation that we gave to the board just a few weeks ago about remote bar exam research and an update on our exploration of different topics ahead of July 2024. So just quickly as a reminder, the committee directed the State Bar to transition to a one-day remote administration in the future. We have since then conducted truly an office-wide exploration to determine feasibility for what we have been aiming for, which is July 2024. There's been a kind of a balance of different priorities, one being the necessary cost savings for the Office of Admissions to improve its budget position, but also to address exam security issues. And I believe this was mentioned earlier in today's meeting, but to address testing accommodation delivery in a remote setting. So we've conducted really a broad set of research, one being kind of data-driven using our post-exam surveys and exam outcome data. Some top-line findings from that suggested that there was no statistically meaningful difference in performance between in-person and remote exams. And also, just to go back to the testing accommodation question, no meaningful difference between those who took an exam in a remote setting who had testing accommodations compared to those who did not. So that really gives us a good foundation to look at this topic. But recognizing that kind of the logistics and execution require some thought, we perform some other research. So for example, we've engaged a multitude of other jurisdictions and potential partners. To name a few, we've been in contact with the state of New York, who developed some novel remote exam approaches using Zoom and other technologies. We've spoke with some international licensing and other licensing entities here in the US about their remote exams. And we also worked with some interesting partners at other departments that offer in-home services to explore kind of a novel approach of in-home proctoring delivery. Of course, I revisited kind of the existing suite of technologies that we've used and identified some new remote exam approaches and technologies. One that has some interesting benefits would be a dual camera approach. This was something that was brought up during our testing accommodation forum as well. And we've also just reviewed our internal processes related to the testing accommodations application process. Make sure it's designed and set up for what could be a remote exam and the certain kinds of requests that individuals would need to submit. So we presented to the board in November a multitude of models. One of them is continuing the reduced facilities model that we are pursuing in February. What if we continue that in July? We compared that to administering the exam using our existing technologies, such as ExamSoft, new technologies, and kind of a combination of our current technologies and some of the novel approaches, such as the in-home proctoring. Our preliminary recommendation at the November board meeting was to continue the reduced facilities model that we are administering in February, mostly because there are just continued uncertainties around new technologies. We really want to be able to research and test these technologies, make sure that they're scalable, and just answer some challenging questions before we introduce a new approach. So we are, between the November board meeting and the January board meeting, are continuing that research, going to be revisiting questions that are remaining, and we will be making a final recommendation for the board in January.
Questions for Cody? Oh, Alex Chan.
Thanks, Cody. I appreciate it. It is a very good summary of what has happened. If I remember at the last meeting, I think it was David Torres who possibly mentioned that there are other facilities that may be a lot more affordable than the traditional facilities. And I think, and someone, can correct me if I'm wrong, and he mentioned either the Naval Shipyard or something along that line. And also, just out of the blue, have we considered perhaps facilities at different law schools who may offer up the facilities for testing purposes? Because I would assume those facilities would also be accommodating to the applicants as well. So have we thought about those options?
I can share a little bit, but definitely we'll open the space to others here who work more closely on facilities. But certainly when it comes to law schools, we do engage our law school partners. I think often there are spaces that at face are appealing, but when we review kind of the multitude of requirements necessary for high stakes exam, they become challenging. So what might be a large campus may actually only be able to provide a limited number of spaces available because of the layout of the spaces. But I'll leave it there and maybe open the floor for someone else here who works on facilities more closely.
So Alex, oh, go ahead, Tammy.
Sorry, Amy, I was going to take this one.
Yeah, please.
So when we're looking at facilities, we are looking at costs. That's always a top priority for us. However, Cody is right in regards to, we also have to take other attributes into consideration. So for example, do they have enough space to do what the number of applicants we need in that location? Do they have appropriate lighting? Do they have air conditioning and or heating? There's a lot of different facets that go into considering whether or not a facility will be feasible to use. And as much as we can, we do use places that are less expensive, but you do have to balance the cost of what it would be to add sometimes additional lighting, and does it really end up saving us money at the end? So we do take all that into consideration. In the past, some of you might remember we've been, Del Mar Fairgrounds, we've been, in the Pomona Fairplex years ago. So we do go to those places that are less expensive, but we always have to consider what are the conditions of what we're being dealt with and will they fit the need of what we need to do.
And I do want to point out that we explored, at David's suggestion at that last meeting, because I think that he suggested that at the June meeting, we went back and looked at government buildings and so on. And I do want to highlight that that's how we ended up also with a judicial council on our list. So if you look, we're using for February, we're going to be using judicial council space. We're being offered that space for free. And that was based on that recommendation from David Torres to look at other government buildings that would be available to us. So we took some of that advice.
Thanks, Amy. I'll buy him a beer for his great recommendation as always. One thing I wanted to note, given that I think at the last meeting we have also approved the motion to reduce the number of facilities. I mean, currently, how many facilities do we still have, at least for the next administration of the bar exam, as well as the one after? So this is the one in February and also for the one in July. How many facilities are there in total for both?
In February, we have 7 facilities compared to normally we would have somewhere between 10 to 12. And for July, I don't know that we're finalized in that, but normally we have upwards of about 15 test centers during a July bar exam. We are trying to achieve the 7 test centers again, but because we've had larger numbers from this past July, and we've seen an increase to testing accommodation numbers. We are currently looking at that to see if that's still going to be viable.
Vince?
Vince, you muted.
Yeah, third time, Vince.
How's that?
Oh, there you are.
Time to give up on this stuff. Thanks, Cody, for your report. Could you jog my memory on what's the definition of the in-home proctor? Is that part of ExamSoft's platform, or how does that work?
Yeah, no, that's a great question. And I gave us an abridged presentation, so we didn't dive into the details. Well, let me first take one step back. An application like ExamSoft would be typically like record and review approach, right? So an individual is launched into the exam has some sort of video technology, records it, and it's not a live proctor situation. There's also newer technology as part of the new remote exam technologies that we explored that could facilitate live proctoring on camera like this. It becomes logistically challenging at large scale. The in-home proctoring approach was a third component that really was about delivering the most challenging testing accommodations to individuals in their home. And so, for example, let's consider someone perhaps who needs, let's say, a bathroom break, and the environmental scan that a typical remote exam administration would provide isn't enough to confidently provide exam security. What we wanted to explore was, could we bring an in-person proctor into an individual's home so that we can allow them to take the exam remotely from their home, but provide a higher touch level of proctoring. And so what we researched and the conversations that are continuing was to partner with stakeholders, potential partners who have a pool of employees that have particular skills that are valuable for this kind of proctoring. So we initially engaged the Department of Social Services that registers what are called in-home support service employees. Through that conversation, we were introduced to the labor organization that represents these employees, SEIU, and also the trade association that represents a segment of these employees that work for private organizations. A large portion work essentially freelance, and there's a portion that works for organizations. And so this conversation is continuing with these partners, but the thought was that just like how we recruit proctors for other needs, we could recruit proctors from this particular pool who have experience dealing with the sensitivities of being in someone's home. And so there's more research to be done there. There's potential partnerships between these organizations or the labor organizations that require some more exploration. But this is kind of a novel approach that we wanted to look into because we think it helps address those most challenging testing accommodations that are hard to deliver in just a purely remote setting.
Okay, thanks. Yeah, that sounds complicated, but it's not everybody's going to need this kind of proctoring. So
true, it would be a small portion of the exam takers. That's a good point.
Here you go to got a question, sorry. So it might be captured under your third bullet point in terms of new proctoring exam delivery options, but have we considered engaging, again, just exploration of the idea that we could have the bar exam taken at different testing centers around California? I mean, obviously we have a number of standardized exams like LSAT or SATs that students can take at different testing centers. And so I don't know if this is sort of one of the options that is under consideration, but can you sort of elaborate on whether this is an option under consideration?
I can take that because that was part of my research assignment, Alex.
for it.
So I really like that approach, and that is how the MPRE, the ethics exam, is delivered by the NCBE. So our applicants would be familiar with that because they all have to take the MPRE as well. So I talked to the same vendor that the MPRE, that NCBE uses for MPRE, and the problem there is twofold, although I think hopefully we can move that way eventually. You have to have a certain question bank to be able to open up a testing window long enough to accommodate how many applicants we have for a July exam. So a July exam, if it's up to 8,500 applicants, the burden on the testing centers would be such that they might need like a 2-week window, which would mean we'd have to have, so many more questions in our bank to deliver of their written portion. And then the second problem is the NCBE does not allow testing centers to be used for the multiple choice section. So then we still have to, have this whole combo where we'd have to have facilities in person for that second day. And I think that the way that the testing centers would be utilized best is if applicants could take both days in a shorter window. So it's something that I think is too many question marks and too many things resources we don't have at the moment to work out for July. But I really like the model.
That's unfortunate. Yeah, there's clearly no one size fits all solution here. And also, and maybe going back to Tammy, I'm sorry, I didn't pick up on what you said earlier. I know we're trying to tighten up the belts and trying to reduce the number of facilities, but at some point, there's only so much we can tighten. There's only so many facilities we can reduce. And so is the intent to fully put the bar exam online and allow companies like ExamSoft to take over? Or in the foreseeable future, is this still the plan to hold part of the exam in person and maybe part of it online as well? And maybe Audrey, you can chime in on that as well.
Well, sorry, Tammy, I will let you speak, but as long as we have the MBE, right, the NCBE's content, and they're requiring us to administer that a certain way, we'd have to have that second day the way.
But that's only for 2 more years, right? But that's only up to what, 2026?
How long that they've said? I think they just extended it to, is it February 27th? They've extended how long they will provide the multiple choice. We don't have to continue to use it, but they have extended how long they will provide it. There was a question that you wanted Tammy to answer to in there, though?
Yeah, because I for some reason I thought my understanding is they're phasing out multiple choices altogether.
They are, but I think. Sorry.
No, please, Audrey.
I think because of the jurisdictions they have signed on for the MBE and how many they have signed on for the next gen, they're trying to balance how long they need to provide the MBE portion, and they have just recently extended it to more exam cycles. I think it's February 27th. I can check that as well.
No, I think that sounds right. Given all the issues around, I am aware the NCB is trying to extend, if not has already extended that deadline to allow additional accommodations to the schools to prepare for the UBE. Maybe this is a discussion worthy in the future. If somehow that does get phased out, all the MBs are no longer being tested. Maybe that opens up more options for us to consider, but maybe it's a little too premature to discuss at this point.
Right. Well, and we'll probably depending on what happens or what the court says for us to do, we could have an overarching plan of our own development, how long we'll use, how long we'll do this version of the test and the NCB's multiple choice and all the statutory requirements about how long we have to give notice for changing the exam as well. So.
And the only other thing I wanted to mention, Audrey, if you can just keep me and Dr. Cow and the CBE informed about, if to the extent ExamSoft is being reconsidered again, for example, for future exam delivery, that you at least keep us in the loop. And we certainly want to consider and explore that as an option, or if that is the option that the staff will recommend, we certainly want to know before making that recommendation. Dr. Cal, do you have any input on that? I just want to make sure we understand, given all the issues we had before with ExamSoft, I want to make sure we address those concerns before, fully or reconsidering ExamSoft again for future delivery.
Alex, I share the same concerns that you have, and I think you expressed it very eloquently, and I agree with you on that, that we need to kind of make sure that if there's consideration for ExamSoft, we need to mitigate some of the issues that had occurred. And I think that's what your intent is, right, Alex?
Correct.
Yeah, so I agree with you. Yes.
So thank you, Audrey, for keeping us in the loop.
Of course. Any other questions? I think the last thing I have here is just a reminder. It's not a very sad farewell when we end today because everyone's coming back for a special meeting. I got commitments from all of you on December 14th. We need to have the special meeting for a very important standards item, and timing wise, we could not hold that conversation today. So I will see all of you on December 14th. It is a Zoom meeting. And then we have our in-person meeting on January 26th, 2024 in Los Angeles. So that'll be very exciting to see everyone in person.
Audrey, can I ask for the special meeting on December 14th so that we as the CBA kind of anticipate, are we expecting sort of that it will be like a 2-hour meeting or
Yes, I believe
longer
that's what
or shorter?
I believe I set it for 2 hours. That is my expectation. I believe 11:30 to 1:30. Is that right?
And
I can make sure I've got that right.
And that should be enough time.
Yes.
And then Audrey and Paul, I guess the question I have is, have we, and I know we'll talk about this as a special session, but have we received any communication from People's College about what their possible, I guess, intent is? Or that's going to be discussed then?
Oh, I talked to Natalie yesterday, and what she told me was that their responses are due about now. I think it might be today, and then she'll be working on a write-up to be hopefully be posted at the end of next week. Is that right, Natalie?
That's correct. Thank you.
I think we need to finish closed.
Well,
Oh.
I have one question about LA.
Sure. Yes.
Should we be, are you going to be getting a block of rooms for us, or should we make our own reservations?
Devin, where was the general services advice about that? Because I think it's gone back and forth about what is actually cheaper.
I think for the June meeting, when they attempted to get a block of rooms, it was actually more expensive than committee members individually booking. But we can look into that and then let you guys know next week.
Okay,
Yeah, let's do a little research. Go ahead, Paul.
Okay, because otherwise I just book them through Concur, and it worked okay the last time. But it is something where waiting till the last minute might leave us with more expensive rooms or no rooms available. So we should probably get on it.
Yeah, well, and with the holidays and everything, we want to put information out soon. So that's a good note for Devin and I to get something out to you next week.
Great. So Audrey, that concludes the director's report?
Yeah.
Okay, great. So it looks like we have finished our open session. And now I'm going to ask that all of our members go back into closed session to finish the remaining closed session items that we still have on our agenda. So, all right, we'll see everyone in a few minutes. So I just wanted to announce to everyone that we have finished our closed session. And now the meeting will be going into recess into tomorrow morning at 9 a.m. The attorney members will meet in an open session using the panelist link by Devin that was sent earlier. And then we'll go into closed session for the question selection sent via the closed link. So I'd like to call for a motion to recess this meeting. May I get a motion?
I thought we were going to go immediately into closed session and then just come back into the open. Was that the plan? Because we're recessing, we don't have to open it up in the morning? Caroline?
No, sorry,
Okay.
it's as Michael described.
Okay, I'll make the motion then.
Thank you, Paul. May we get a second?
Second.
Thank you so much, Alex. No discussion, so let's go ahead and do a roll call vote.
Dr. Bolton? Robert Brody? Alex Chan?
Yes.
Jim Efting? Kareem Gangora? Paul Kramer?
Yes.
Larry Kaplan? Alex Lawrence?
Yes.
Esther Lynn? Justice Macy Walla?
Yes.
Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna?
Yes.
Vince
James
Reyes?
Bolton is here. James
Yes.
Bolton is here now.
Thank you.
Did you get Dr. Bolton's vote, Devin?
I did. Thank you.
Okay, great.
Alan Yokelson?
Aye.
Dr. Cow?
Yes.
With 10 yeses and 0 nos, the motion passes.
Pardon me, did you get my vote, James Bolton?
I did. Thank you, Dr. Bolton.
Yes.
All right, thank you, everyone. So for attorney members, thank you for working hard coming tomorrow. We appreciate it. And then for the rest of us, we will see everyone else on our next special session meeting on December 14th. Thank you. Bye-bye.
Thank you.
Thank
Have
you.
a good weekend.